Hello and welcome to my presentation on assignment and novation of contracts. I am pleased to talk today on the definition, requirements, and legal implications on assignment and novation in agreements, particularly in construction contracts. The employer may assign its rights to have the works constructed and its rights to sue the contractor in the event that the works are defective, but not its obligation to pay for the works. The contractor may assign its rights to payments of the contract sum, but not its obligation to construct the works in accordance with the building contract or its obligations to meet any valid claims, for example, for defects. If someone wants to transfer the burden of a contract as well as the benefits under it, then one has to novate. Like assignment, novation transfers the benefits under a contract, but unlike assignment, novation transfers the burden under a contract as well. After assignment, the assignee is entitled to the benefit of the contract and to bring proceedings against the other contracting parties to enforce its rights. The assigner still owes obligations to the other contracting party and will remain liable to perform any part of the contract that still has to be fulfilled, since the burden cannot be assigned. An assignment of rights occurs where one party, the assigner, transfers contract right to another party, the assignee. An assignment is a legal term used in contract and property law. An assignment may not transfer a duty, burden, or detriment without the clear consent of the assignee. The rights may be vested or contingent and may include an equitable interest. The legal position of the assignment and the contractual terms of the agreement between the parties determines some additional rights and liabilities that accompany the assignment. The assignment of the rights under a contract fully transfers the rights to the assignee to get benefits accruing under the contract. The term assignment is limited to the transfer of rights that are intangible, for instance, contractual rights and rights connected with the property. Effects of assignment. The effect of an assignment is to remove privity between the assigner and the obligor, and creates privity between the obligor and the assignee. The assignment must occur in present. No one can assign a future right. Where assignments are allowed, the assigner is not obliged to have consultation with the other party to the contract. He can just assign the rights. The assigner shall be liable unless there is an agreement to the contrary by the other party to the contract. The parties must intend to create an assignment at the time of the transfer. In the case of National Reserve Company and Metropolitan Trust Company, the court ruled that in determining what rights are interest transferred under an assignment, the intention of parties is inferred from the instrument shall prevail. An assignment takes with it all securities held by the assigner, which are collateral to the claim, including all rights arising in consequence thereto, and gives to the assignee the equitable title to the collateral securities and incidental rights. Definition of novation. In a scenario where liabilities are transferred to a third party with the consent of the other party to the original contract is defined as novation and will evinced by a tripartite agreement to novate. A novation will transfer both the benefit and the burden of a contract from one party to another. A novation creates a new contractual relationship and a new contract is entered into. Characteristics defining novation. In the novation agreement, following characteristics must exist. Novation must be a tripartite agreement. All the parties give their consent. The novator has been released from the obligations. There has been an acceptance of the terms of the novation on the part of the novatee and the substituted party. There is vesting of remedies. Assignment or novation. Legal position. If a document is titled as a deed of assignment and it refers to the transfer of responsibilities and obligations and is a tripartite agreement, it must be noted that these are the characteristics of a novation as opposed to an agreement, an assignment. Important point in such scenario is to understand that whether by making use of the word assigning or assignment actually affects the characteristics of the document. The court clarified this. In Badana and Leeds Teaching Hospital NHS Trust, by majority the Court of Appeal decided that on the facts of the case, although the deed of assignment in question referred to an assignment of the benefit and burden, on proper analysis there was indeed a novation. In Langston Group Corporation and Cardiff City FC, the court made it clear that although the variation agreement in question was not incorporated with the word novation, the circumstances and effect of the agreement was indeed a novation. So a new contract had been created. If a document is not described as novation and it contains the key characteristics of novation, then the court will accept this document as a novation and not assignment. Conclusion. Parties need to be careful and must assess and consider what they want, whether to assign rights or to novate rights, along with obligations. When deciding whether to assign or novate, parties should consider the following: whether there are in fact liabilities and burdens to novate, whether the novatee will be willing to take on the liabilities and burdens, whether all parties will consent to the novation and indeed enter into the agreement. If there is no liability or burden under the contract to transfer, then an assignment is likely to be the most appropriate way to transfer the benefits and to transfer the interests. Thank you.